Alright, is everyone ready?
Plessy, you ready to get on the train in the white section?
Yeah, let's protest this dumb law.
Okay. 10-4. I'll be on that bus to make sure Homer Plessy doesn't get away with this.
Excuse me, sir, you need to get off this bus. You're not allowed to be in this section.
I have every right to be here. There's nothing different between us.
Okay, well, maybe, but you're still 1/8 color and you still can't sit in this section. Yes, and if you don't get off, I'm going to go get the conductor.
With all due respect, ma'am, I have every right to be here.
Excuse me, conductor, this man won't leave our section.
Where's Homer Plessy? You have violated the separate car law and need to get off this train. Homer Plessy, you have the right to remain silent. Anything that you say or do will be used against you in the court of law.
On June 7, 1892, Homer Plessy was arrested for being in violation of the separate car law for sitting in the white section of the train. Homer Plessy was 7/8 white and 1/8 black. He was appointed by the Committee of Citizens to purposely violate the law. This committee was made up of whites and non-whites in support for racial equality. He was sitting in the white-only section when asked to leave, and then he refused. The purpose of his protest was to show that all races should be allowed to sit in the same section. The issue at hand was if the Constitution gives power to the states to uphold the separate but equal legislation. So basically, can the state separate people based on their races when using public facilities? Something to think about that we will digress later is what this does in violation of Plessy's 14th Amendment rights. Based on the separate car law, citizens of color are discriminated by and not given the same public facilities as whites. This protest was the beginning of the fight against segregation under the 14th Amendment.
On May 18, 1896, the U.S. Supreme Court, by a 7-1 majority, upheld the ruling and confirmed that Plessy did in fact violate the separate car law and that the law is constitutional. So yes, the states can constitutionally uphold this legislation that allows the different races to remain separate but equal when using public facilities. Justice John Marshall Harlan was the only dissenter and argued that under the 14th Amendment's Equal Protection Clause, all people were created equal. The law was taking away freedoms from both blacks and whites that are guaranteed by the Constitution and regulating them based on race. The 14th Amendment states that all persons are citizens of the U.S. and states are forbidden from enforcing any law which shall abridge the privileges or immunities of citizens. So, nowhere in the 14th Amendment is there discrimination based on race, and all rights are given to all citizens, and because of the 13th Amendment, all African Americans can be citizens of the United States.
In Justice Harlan's words, our Constitution is colorblind and neither knows nor tolerates classes among citizens. In respect of civil rights, all citizens are equal before the law. The humblest is the peer of the most powerful. The law regards man as man and takes no account of his surroundings or of his color when his civil rights, as guaranteed by the supreme law of the land, are involved. In my opinion, the judgment this day rendered will in time prove to be quite as pernicious as the decision made by this tribunal in the Dred Scott case. The present decision, it may well be apprehended, will not only stimulate aggressions more or less brutal and irritating upon the admitted rights of colored citizens, but will encourage the belief that it is possible by means of state enactments to defeat the beneficent purposes which the people of the United States had in view when they adopted the recent amendments of the Constitution. So while at the same time of this case segregation was not seen as wrong because of the equal part of the separate clause, Justice Harlan had a good point, and Plessy did have every right to sit where he wanted. Also, just because they say the separation is equal and all the same accommodations are given to both races does not mean the separate spaces were the exact same, and usually there was a difference. This case and Justice Harlan's dissent soon was the primary argument against racial segregation, which eventually was ruled unconstitutional in public.
To be an American, where at least I know I'm free, and I won't forget the men who died, who gave that right to me, and I gladly stand up next to you and defend her still today, 'cause there ain't no doubt I love this land. God bless the USA.